Good afternoon, everyone. Thank you for joining us. Good morning if you're joining from the West, and good evening if you're joining from the East. My name is Tamara El-Shabib. I'm the Senior Patent and Tech Transfer Consultant at Gowling WLG based in Dubai. Thank you for joining our third session of our webinar series on tech transfer and innovation. Before we start with panel introductions, I wanted to introduce the webinar series for those who are new to it. The purpose of this webinar series is really to discuss different topics within the umbrella of tech transfer and innovation, and to share knowledge and experiences and identify challenges and solutions within this area. The focus is normally on the GCC region, but we do look at experiences from other jurisdictions and lessons learned. For today's discussion, we are focusing on IP management strategies for universities and R&D organizations. Both organizations are crucial in creating new knowledge and in supporting the utilization of that new knowledge through research, through publication, and then through tech transfer as well. And having the right IP management strategy is crucial to a technology's chances of reaching the market. So in today's webinar, our panel of experts here will be sharing their experiences and their perspectives on strategies for protecting and managing your IP and the ways that you can show the value of your IP management activities. There will be an opportunity for questions at the end of the session, so please leave your questions in the Q&A chat. You'll also be prompted to complete a short survey at the end of the session. We'd appreciate any feedback you can give us. If there's any specific topics you'd like us to cover in future sessions, please let us know. With that, I'd like to turn to our panelists and ask them for some quick introductions. And the first one on my list is Winsome. Winsome, can you tell us a little bit about yourself?
So my name is Winsome Dunn, and I am the manager of intellectual property and agreements here at Khalifa University. I have spent several years in doing patent prosecution in both big pharma, biotech, as well as academia. By way of biotech, big pharma, I was with Chiron Corporation, which is now Novartis, and they have the HCV portfolio. I then moved on to Roche and handled part of the PCR portfolio, and then on to Emory University in Atlanta, where I worked with setting up the first patent group within the Technology Transfer Office. I then went over to Saudi Arabia, did likewise, and now I'm here at Khalifa University doing the same thing. I'm here to answer questions and quite open to discuss the way that we manage our portfolio here, how we maximize research in terms of market and strategies, and in terms of managing our IP filings and budget constraints, the entire cake.
Awesome. Thank you, Winsome. Trevor, can you give us a little bit about yourself?
Sure. Thanks, Tamara. My name is Trevor Newton, and I'm a partner in the intellectual property group here in the Ottawa office of Gowling WLG. I'm a registered patent agent, and I work primarily with companies in the pharmaceutical space, biotech space, and with universities in those technological areas. And I prior to becoming a patent agent, I didn't necessarily move around quite so much as Winsome did, but I moved down to Boston, and I was working in the research labs, actually, of the infection discovery group at AstraZeneca in Boston. And I've worked in the infection research group at the National Research Council here in Ottawa, Canada. So working on both sides of the IP spectrum, so to speak, to develop and also now seek to protect and work on behalf of my clients to really to secure the best protection for the IP that comes out of the lab.
Yep.
That's essentially it.
Okay. And then Vivian.
Thanks, Tamara. Hi, everybody. My name is Vivian Wei Chen. I'm a patent attorney of Juris Asia LLC, which is the Singapore office of Gowling WLG. I'm a registered Singapore patent agent, and my main role is drafting and prosecuting patents, mainly in the biotech and biomedical fields. I also provide strategic advice in a lot of technological areas, including AI. I also provide due diligence in terms of prior search, freedom to operate, and provide support for litigation. And prior to being a patent attorney, I have an academia background. I spent 4 years working in the Agency of Science, Technology and Research, A*STAR for short, of Singapore, in a research lab. So doing interdisciplinary research, covering biotech and nanomaterials, before I transferred to the tech transfer office of A*STAR, handling thousands of A*STAR's patent portfolios. Then after that, I went to the law firm and trained to become a patent agent.
Thank you, Vivian. So we want to hear more about that experience. So before I jump in, I'm going to just quickly put up the topics that we plan on covering today. So the webinar is organized as more of an informal discussion. So depending on where the conversation leads us, hopefully we'll be able to cover all of these points, at least to some extent. Jumping straight in, I wanted to sort of start off talking about the IP management practices at the universities that you've had experiences with, or the R&D organizations. And when I talk about IP management, I'm talking about points 1 to 5, which is basically, the functions within a technology transfer office or an IP management office that deal with sort of identifying, capturing, evaluating, and protecting IP that's generated from R&D activities. Not so much the commercialization aspect, which is sort of like your marketing and licensing and how to take ideas to market. So if we just, let me go back. If we just sort of go around the panel, and I'm going to start with you, Winsome. Can you tell us a little bit about how KU, being a federal university, manages IP generated from its research programs?
So here at Khalifa University, we both have internal and external granting or sponsored research. There is more internal than external. We are fortunate here in the UAE that mostly money is not an issue. So unlike universities in the US where they're always looking for money in every place on earth, here at Khalifa University, we have the internal funding, which is a lot of money, and there's also external partnerships. The first thing that we have in place is a invention disclosure, that we try to use that as the tool where we advise the faculty that unless they fill this in to the max, because it has areas that it really provide us with a good feel of what this invention is about. So there's certain aspects of it that you do the background and the summary of it. One aspect that we always try to get from them in regards to the knowledge is explain to us what the market applications are, because the goal of you even filing your patent application is there's always that commercial component. So you always try to get from them to explain to you the market applications and anything that could be in terms of commercial products that's close to what they're doing, companies that would be interested. etc.
Does,
You,
sorry to jump in. I just
Go
have
ahead.
like questions coming at me. Does the university sort of have IP policy that sort of covers all?
absolutely, absolutely. So, and from people get here, from the orientation is when we try to get in to sort of start or process of educating them in regards to what the policy is, and you know how you should report your invention disclosure. And we're fortunate here in the department, in the TMI department, where I also handle agreements. So that also helps the inventors or the PIs with their industry outreach. So once they get in terms of the orientation, and we expose them to what our process is, that, you know, the invention disclosure, we also discuss the IP policy with them, because that provides guidance. The first thing that usually comes to their mind is their invention anyways is always the best, the greatest, and, you know, blah, 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 write down. And well, how much money will I get? So there is also, the policy also governs how distribution of revenue through licensing will be managed. So it's really comprehensive. And it helps us to help them to understand what the process is, what the expectations are. We also try to introduce them to the different portfolio managers, whether it's physical science, whether it's electrical engineering, the engineering, or AI software. So they'll know that we have various technology managers handling portfolios in various ranges. So
I think the IP policy is so important for any organization that's running an R&D program, because I think it can also help to attract researchers as well. So I feel like a lot of them ask those questions like, you know, what is the royalty distribution? What's in it for me? And I think one of the ways that I've seen some institutions in the region, you know, tackle this, or at least stand out in this aspect, is by sort of playing around with the royalty distribution. So for example, if they're looking more at retaining, you know, the best researchers, you know, most universities have an average of like a 33%, you know, royalty towards the inventors. Some institutions will go up as high as 50%, just to sort of keep and retain the best talent. So there are ways, I mean, it is an important document to have as sort of a guide for researchers. So when it comes to, you know, what are their incentives for participating in IP management and commercialization, but also as a guide internally in terms of like, you know, when you have something, who do you talk to? How do you disclose it? You know, are there any things you need to keep in mind in terms of, you know, can I go and discuss what I've created with anyone? Or is there a particular process for, you know, public disclosures? So very, very important that an IP policy is in place. I think early on, I would even say that if you're just new to setting up like an IP management function, that's probably one of the earlier things that you need to be working on, is sort of an IP policy that can, you know, basically set out the organization's position when it comes to managing IP.
right.
Vivian, you mentioned that you also spent some time in a tech transfer office, and I think you said it was A-Star. Can you tell us a little bit about your experience?
Yeah, so A-Star is actually a very important organization and plays a key role in the Singapore innovation system. So it not only have cutting edge facilities to facilitate all kinds of research, but also have a special effort. It puts in a lot of effort in nurturing the local talents. So back in the 1990s, the predecessor of A-Star was founded because the Singapore government identified the potential of biomedicine. So the then chairman went around the world looking for top biomedical talents and persuaded them to come to Singapore. And so these top talents, the chairman called them whales, will bring the expertise here and teach our local talents, which are called guppies. And the guppies are trained under the whales with the aim to becoming wheels themselves one day. So because of this initiative, Singapore's biomedical sector has been thriving, with many of our homegrown scientists doing cutting-edge research, and many have even developed and commercialized their own work. We have also attracted like major projects, including, for example, Sanofi and BioNTech for vaccine manufacturing facilities. And without doubt, this has made significant contributions to Singapore during COVID-19 pandemic. And similar stories happen at other tech fields. So because of all these efforts, A-Star is one of the largest patent filers in Singapore. The R&D talents really generates lots and lots of high quality IP. And these are all supported by a very good IP management and commercialization infrastructure in the tech transfer office. So back then when I was working there, we have a highly qualified and a well-trained team. And many of us was with advanced technical degrees and even with certificates in IP law. So usually the working schedule will be meeting inventors to discuss and understand their IP generated, to handle due diligence, mainly prior art search, and making decisions of the IP portfolio management in terms of whether to proceed with patent filing or keeping them as know-how, or combinations of various forms of protection. So if a decision is made to proceed with patent filing, then we have to evaluate in terms of how to file as a provisional as is, or with a set of claims, or with a full specification, and where to file and when to file in terms of if there's a prior disclosure or an intention to disclose the invention. And we also constantly collaborate with the commercialization division to commercialize the A-Star's IP portfolio. So I would say there's a lot of communication with various parties. And after the entire tech evaluation process, we will have to discuss with patent agents to come up with the best claiming strategy. And then we will have to manage the whole life cycle of the patents all the way until ground. And it's very important to supervise patent families, which may cover multiple jurisdictions. And sometimes we have to make decisions in terms as accelerating some important patents, delaying some, or even pruning some. So it's very important to constantly talk to the commercialization department to understand the marketing opportunities for a particular technology, because that can have an impact on the patenting strategy.
Definitely. And I think it's interesting to see as well how A-Star as a research agency also has a very sort of comprehensive tech transfer function. So not only does it like fund research, it conducts research as well, but it's also managing the outputs of its research. So I think that's really important to see as well, that it's not just something for universities. Research agencies need to be good at it as well. Trevor, I'm going to move on to you. Just based on your experiences with Canadian universities, is it sort of a similar function as well in terms of how they manage the outputs of their research?
Yeah, I would say yes. It's quite similar in that, excuse me. There's definitely a very strong requirement for an IP policy. I do find often that the IP policies are quite different between universities, and I think it's interesting to me because there's different. It gives the universities some different levels of flexibility as how to work with licensees, perhaps. And the way that I work, not being inside the universities or inside the tech transfer office, but more kind of at the intersection between the universities and companies that might actually be carrying out the commercialization, such as spin-out companies and that sort of thing, is that the early stage development of the IP from the lab to the tech transfer office is critical in order to help the early stage companies raise capital. And so having an IP policy in place really is helpful to the spin-out companies or all the SMEs that might be developing the IP that comes from the labs. Because the core of the value of the company often is actually in those first patent applications that are filed. And this is even more so in the biotech and pharmaceutical space, where there's maybe not quite so many patent applications that are filed. So having an IP policy that includes an audit perspective of it too, I think is key, not just to ascertain what you have within the growing portfolio from a lab, but also to manage the budget that is going to be required in order to maintain that IP, because it does get costly, especially when you get into national phase campaigns, like filing applications all around the world and all the translations that come along with it. So having that IP policy and including an IP audit component to it is quite key, especially to helping the researchers in the lab, but also the companies that develop the IP from the lab succeed.
Yeah, and actually just picking up on that last point of yours, having sort of an IP audit sort of mind frame when you're looking at these R&D projects, I thought it might be helpful to set out like the kinds of R&D building blocks, if you like, that are used in the research process. So when you're looking at capturing IP, you're not just looking at inventions and technical solutions, you're looking at anything that can be sort of bundled together with that can help sort of increase the value of the IP that you're licensing out to a spin out or a company. And it's really important how you capture these assets. And so there are sort of standard ways that tech transfer offices do that. And that's sort of using, as Winsome mentioned, an invention disclosure form. So that's a tool where you can basically capture what are sort of the new and inventive sort of features that have been generated in the research. And I would say even, especially nowadays, it's become so much more important to have either questions related to software in the disclosure form, or maybe even just a standalone software disclosure form, because a lot of the inventions we're seeing today have software component. And it's really important, if that software has been developed using open source, that we're able to look at whether there's any restrictions or limitations on owning the software that's been generated or commercializing it. And so you need to have those questions in the form, ask the researchers, have they used open source? What are the licenses? And then as part of the due diligence, look at those open source software licenses and see, is there anything you need to be aware of before you invest more in trying to protect and move forward with it. There's other ways as well that you can sort of capture those assets. And so there are knowledge management systems that can help you sort of, track your patents, of course, but some of these are also designed in a way to help you capture other assets. So they're more like project management systems, and you can sort of put in details about your research projects and then add in all the assets related to that project. And those can be a bit helpful when you're looking at not only at just patents, but you're looking at other types of assets listed in the slide before. You need to capture as much of that into that docketing system, and then later down the line, when you're looking at commercializing and you're maybe demoing something, that's when some of that data might become really helpful. And then also trade secrets. So sometimes you might not necessarily file a patent for something, you might be looking at protecting it and sort of keeping it confidential, but you do have to show steps. You have to take steps towards maintaining something as confidential in order for it to be protected as a trade secret. And so there are management systems that you can use that can help with keeping things, managing your trade secrets as well. And then, of course, agreements are another type of tool as well that you can use. So turning back to you, Winsome. What would you say are sort of the main criteria you look at? So this slide is basically, almost like a brain dump based on what I remember doing when I was at the tech transfer office. So we would look at ownership, we would look at, the technology in question, how unique it is, what are the strengths of the technology. And then we'd look at, the market for it. So what is the commercial opportunity? And then we would also do an IP analysis. So based on how things run at KU, would you say this is sort of the same?
All of
kind
it.
All right.
All of it. And in particular, the patentability test.
Yeah.
That is foremost in the back of our minds. We do like an internal review first.
Yeah.
And then if it seems to, at least they say, pass the smell test per se, we sometimes engage a third party.
Yeah.
Third party out there to do a more comprehensive analysis.
Yeah.
And once we get that back, we just don't necessarily take their word for it. We have a numbering system.
Mhm.
And if it gets to a certain number, that is you're checking the patentability, the landscape, the commercial, applicability, etc. If it gets to a certain number, based on our analysis, that is when we start doing a more deep dive into, okay, the interview with the inventor, seeing who are the inventors, if they're collaborators. And one of the things that we try to do as soon as we're evaluating and we know that there's a third party, and if there are no other agreements, if there are agreements that speak to ownership, the first thing that we try to do is to reach out to the co-owner.
Yeah.
And then try to work out a IP management agreement. We try to get that on the ground before we start. So most of the time, most are not able to, don't have the funds to pay for whatever we need done, whether it's the patent costs, commercialization costs, whatever. And you try to hit the ground with them to say, okay, so we will pay X, Y, Z. However, that means it will reduce the amount of revenue you get, so you work certain things out in the agreement, but all of this together. And sometimes we also use like other softwares like Lux or Frost & Sullivan and a few more to assist us.
With the market analysis and
absolutely. Yes.
Yeah, I think that's key as well. I think it can add a lot of pressure to a small tech transfer office to try to be experts in all areas. I think it is important to reach out to experts in the different tech or market areas that you're looking at for like specialized reports. And I guess, Frost & Sullivan, just we did a little ad for them right there, but I think a few of us have used them before for doing these kind of analysis.
Yeah. The other thing that you have too, once you're doing this evaluation, you may come across something that it's not patentable for whatever reason. So especially with the software and the AI, that's sort of new to us and to most researchers, is that no, you can't go use somebody's algorithm and say you make it better and then it's patentable. You kind of say no, you can't do that. There are encumbrances here. So sometimes you look at what they've done and you have to either take two roads. Either you're going to keep it as a trade secret because it is of value and it has its uses, or if you may just have to copyright it, So you then have to choose whether you're going to do a patent, you're going to do a trade secret, or you're copywriting.
Vivian, how did you evaluate invention disclosures? Was it any differently to what we're talking about?
That's quite similar to what Winston does at California University. So A*STAR has been using a very well-designed invention disclosure form template. So for the inventors to disclose their inventions, they have to submit that form to the tech transfer office for evaluation. So the information we require is really very detailed. I mean, the tech details of the invention would typically be at a scientific publication level. And the inventor's information will include residential information, citizenship, because in some instances, for example, inventor is an Indian resident, we have to obtain an Indian foreign filing license before we file the application, for example, in Singapore first. And we will require the inventors to describe the known prior arts, any problem solved by the invention and the advantages of the invention, any of the potential licensees that they know, any known competitors, any intended public use or public disclosure in terms of conferences or scientific publications, or even business impact of the invention, such as whether it's easy or is it difficult to design around the invention. So in my opinion, a good invention disclosure will not only describe the invention, but will sell the invention by describing its advantages in preferably quantitative terms compared to its prior arts. And it has to emphasize the features that provide advantages, because this will make the tech transfer manager's job much easier in terms of during the later prior art search process. Evaluate the invention in view of the prior arts, and determine the inventive concept. So once we receive the invention disclosure form, we will typically have an inventor interview to obtain more information to supplement the invention disclosure. For example, to obtain additional details on the deadlines of filing, or determine the broadest concept of the invention. It will be also very important to understand the next stages of their research. For example, are they going to invest more efforts and money in this project down the road, maybe in the next 12 months? Because if there's more data generated, we'll make sure that they can be incorporated at the conventional stage, and in the provisional application that we file, we have to put in some statements there to provide support. So after that, it will be the time of reviewing the invention disclosure and do a prior art search to determine if the invention is clear for seeking a patent protection. So we use databases like the major patent databases, and including all the non-patent literature search. So I would say it's quite critical to determine the correct search keywords. Then determining the searching keywords will require some kind of knowledge that equivalent to a patent agent's drafting skills, because you don't determine the keywords based on the invention itself, because which can be only an embodiment of the inventive concept. So after the prior art search, we will do a patentability assessment where the inventive step issues will be examined to determine the strength or weakness, like is it unsurmountable inventive concept step issues, or it is possible, there's possibility to overcome it, or it's clear for patent, for proceeding to file patent application. So if there's some inventive step issues that are identified, then it's critical to go back to the inventors to get a secondary consideration. If they can provide any arguments to say that probably the identified prior art putting together will not destroy the inventive idea, to suggest any kind of elements of the inventive idea. So again, I think communication is key here.
Yeah, and I agree in the sense that as well, you need to have an idea of these things before you invest in like patenting as well. So if there are issues with inventorship or ownership, or even if you're able to get the marketability assessments done earlier on, you almost want to know before you invest in patenting. Trevor, I'm gonna jump to you. Can you give us an idea? Yeah,
just one quick thing. One of the things that we have been doing here is that we've been having the library, in collaboration with the library, we've been doing a market, a patent and patentability seminar with students or, just anybody who would be interested. And something that we are now teaching them how to do is how to do the search. And it's using the classification system.
Okay.
So we have them checking different databases, just sort of, it's our way of teaching them in order for them that when they provide us with an invention disclosure, we don't spend a whole lot of time actually doing the prior art search that they should have really done.
Yes.
That would have probably saved them the headache that when we first get it and start doing the search is like, did you really submit this without doing a search? So they're getting a little bit more sophisticated here, which
that's really smart. That's definitely one of the techniques I've seen, some of the more advanced tech transfer offices do, is they teach the researchers how to do these searches themselves. And so that helps them improve the quality of their research and the likelihood of their research, moving forward.
Yes.
Trevor, I was going to ask you about IP analytics. What can we learn from IP analytics earlier on? And can they help us sort of save costs down the road if we get them done earlier?
So analytics in terms of searching say background art that might be out in the space.
Background art, but then also like IP landscaping analysis,
Absolutely, and that's especially when you get to the startup phase. We're both looking at patentability, so looking through the prior art and looking through what's out there in terms of what you can get patent in terms of a patent, but also what your competitive landscape is going to look like. And that obviously ties into your market analysis side of things. And having, Winston, that's great that you guys are doing a little bit of training on the searching side of things, because having that ability to go through and find if not necessarily all the prior art, but the relevant prior art that's in your space helps you both from understanding what you can get out of your research program, patent-wise, but also who your potential partners are going to be if you're able to negotiate a partnership with some of the other players in the industry. But looking at the landscape analysis to see where the minefield is, or what your potential challenges are going to be, both from who you might be working with as a partner or as a competitor, who has the deep pockets to be able to actually enforce some of their patents, and how do you work your research program around all of that in order to get the best realization for or the best value out of the research efforts that you have, because it really comes down to that looking at what value comes out of the research lab and how you can commercialize that. And the fewer obstacles that you have between the lab and the commercialization side of things, the better chance you have to be able to raise capital, the better chance you have to be able to succeed in actually developing your product at the end of it all. So the searching and that IP landscape or analytics side of things is something that's ongoing. It doesn't stop, because the research typically doesn't stop as long as you're working towards a product, and there's constantly going to be new IP and new players evolving in the system. So we do the two hand in hand with the companies that we work with, and certainly it's the tech transfer offices have an important part in that as well, because it's really at the early stage of a commercialization program.
Yeah, absolutely. I feel like even having these analysis as well can sort of feed back into the R&D strategy as well. So, when you're doing these landscape analysis, you can kind of have an idea of sort of where are the areas for potential sort of new IP development, or where are the areas that are too crowded and risky to sort of go into. So if you're looking at especially applied research, I feel like that's definitely something that should be done sort of earlier on, probably. Jumping on to the next topic, because I'm conscious of time and I feel like there's so much more we can talk about on the evaluation stuff alone. but we'll come back to that. In terms of IP protection strategies, I'm going to turn to each of you based on your areas of expertise. So I was going to start with Vivian. Sort of how would you work together with sort of a research team to advise on an IP protection strategy for something within the domain that you normally would work in? So biotech or life sciences or medical inventions. What would be the first thing? Yeah.
So one of the very important issue about biotech or life science inventions are the patentable subject matter. So many inventions in this field are maybe based on a discovery, such as some genetic material or microorganism that could pre-exist in the nature. But in terms of patenting this kind of invention, there must be something more to constitute an invention. So for example, to find a genetic material or microorganism pre-existed in nature would be just a discovery. But if the contribution made goes beyond isolating or purifying a material or microorganism that pre-existed, for example, to include modification of it, and so that it can be adapted for a specific use, then both the modified material and the specific use could be considered inventions. And the same principle also applies for a naturally occurring process. So an example would be, for example, a method of digesting milk casein using proteases found in the gut. It will be considered as being directed to a natural process. But if there's a process of producing probably fermented beverages using the natural proteases to digest milk casein, then this could be a specific use of the natural process and therefore could be patentable subject matter. Another issue in this field would be methods of medical treatment. So this is a specific exclusion under industrial applicability, at least in Singapore, and the same provision exists in many other jurisdictions. So the rationale of excluding method of medical treatment or surgery performed on human or animal body is to ensure that our medical practitioners are not unnecessarily hindered from exercising their professional skills by the patent rights. So to give you some specific examples in this field, for example, many of the inventions concern cosmetic treatments. So if there's a pure cosmetic treatment, for example, for reducing the normal hair loss by administering certain compound, it would be considered a patentable non-therapeutic method. But if it has a therapeutic effect, it will be considered as a method of therapy. For example, a treatment of acne. So it is quite important to amend the claims so that you will specify the non-therapeutic aspect of the method only.
I think that's why it's important to work specifically with somebody who's specialized in that area, because they'll know sort of how to draft the claims around some of these exclusions. Trevor, I was going to jump to you. So I know that your background is, dealing with chemical inventions. You've done organic chemistry, pharmaceuticals, clean tech. Is there anything that we need to be aware of within those spaces when it comes to drafting or patenting?
A lot of the same strategies that Vivian referred to are exactly the same in the space that I would work in. Pharmaceuticals, often we're talking about either new chemical entities or antibodies, and there's different laws all around the world around the types of eligible subject matter, but also there's different thresholds in terms of what type of support that you need. And that's what I find often is that if we have a nice new invention, we really like to try and get the broadest support possible for it. And it can be difficult to do that when you have a research program that doesn't have necessarily the same deep pockets that a pharmaceutical company would have, where you can actually put all the resources that you want at getting all the various permutations of an invention evaluated and sort of test the limits to see where things will work and things will not work.
Yeah.
So trying to get the breadth that you need, especially when you're working with the budget of an academic lab, can be difficult. So what, at least with universities and small biotechs that I work with, we try and make sure that they're educated enough that we try and keep publications under wraps as best as possible, which, you know, we know what types of tensions we're working with there. The labs need to be able to publish, but as long as we get protection before those publications come out and make sure that the researchers know what types of additional research work needs to be done before, let's say, a PCT application is filed, because we want to round out those specifications as best as possible to get the broadest possible protection for what will inevitably be a very good invention once you get to that stage. So that's ultimately, it's a combination of education of inventors and timing. And I definitely found over the period of COVID that timing became a real issue, because a lot of the researchers couldn't get into their labs over the course of COVID and that sort of thing. And it was a little bit heartbreaking, really, to see, because I've had a couple of clients come to me and say, hey, is there any way to extend this priority deadline? I wasn't able to get into the lab to complete the work that I needed to finish over the course of the priority year. And of course, there was no such thing as an extension to that priority period. So forward thinking and planning around what your research can actually obtain, or what you can actually obtain over the course of a year, really should be also part of your at least life science, biotech, chemical evaluation when you're doing the initial evaluation of a program. What types of resources do you have to be able to round out an invention nicely?
Yeah. And I think another area where timing is really important is basically in the software and AI space, because you have developments happening so quickly. And I'm just going to jump to that. So just, you know, if you're seeing a lot of inventions in that space coming through, some things to keep in mind when it comes to software and AI, and that's what we're personally dealing with here a lot in the UAE. There's so much going on in this space. Things to know is, you know, we can patent software related inventions and AI related inventions, but there are things to keep in mind when you're patenting in those areas. There are issues related to subject matter eligibility. For AI, there are also issues related to ownership in some jurisdictions as well, especially if it's an invention that's generated by an AI model, you know, who owns it, who's the inventor. Generally here in the region, they tend to look at how, you know, what guidelines have been published, you know, by the EPO or the case law that's developing in other jurisdictions. And also something to keep in mind is generally if you have a set of allowable claims in one of these jurisdictions, it tends to sort of go through the patent office more easily. When it comes to drafting in these areas, you know, usually you need to show a technical purpose. So it does help to draft, sort of start off looking at what is the technical problem, and then what is the technical solution being solved, basically. And that's why you need to work again with specialized attorneys in that space. You know, they'll have an idea of all the publications in that area. They'll know sort of how to get around some of these exclusions. And then also patents can sort of only cover certain aspects, you know, where you can get patent protection, maybe look at other types of IP where you can sort of fill in the gaps with. So, you know, maybe for particular inventions, you might want to sort of do the analysis first before you rush to file a patent. Think about, you know, do you want this published? You know, can you detect infringement? You know, how easy is it to invent around? So these are some of the issues you need to sort of think about when, and I don't think that's just specific to AI and software as well. I mean, if you're filing a patent, you need to be able to sort of monitor and enforce it. So if you can't see if somebody else is using it, the technology, then it's going to be very difficult to enforce it or monitor infringement. So we're going to jump straight into sort of patent filing and prosecution strategies, and then briefly talk about developments in the area. So, when it comes to patent filing considerations, these are sort of the areas we would look at when I was in a tech transfer office, at least. Before we rush to file a patent, we need to think about, what's the budget we have, what are we working with as a tech transfer office? Have they disclosed anything? A lot of times, and I think Winsome, you've had personal experience with this as well, you'll file a patent and then you'll find out that it was already published before filing, and the inventors forgot to mention. So these are things you need to know up front, because not all countries will have disclosure grace periods, and so that immediately removes a lot of jurisdictions. There's ways as well in which you can speed up or delay the patenting process, and different reasons for why you might want to do that. So if you want something to go to grant quicker because perhaps it's an area that's developing really quickly, you want to be able to enforce your patent, you can speed up examinations in the different patent offices. A lot of the patent offices have agreements with each other where if you have a set of allowed claims in one, that can help to speed up the examination in another patent office. If you want to delay decisions because, for example, you haven't done your market analysis, you can, file a provisional and file a PCT, and that'll give you like 30 months to decide which countries you want to go into. So there are different sort of strategies you can deploy depending on the invention that you're dealing with, how far along you are in your analysis, and how quickly you want to go to market. Also, where you file. So, that really depends on, where your markets are. So you would need your analysis to help support that. So where are your markets? Where are your potential countries where you might manufacture? Where are your competitors? Those are sort of the countries that you would normally seek protection in. And then I was going to talk a little bit about updates in the region, but I think I'm going to sort of skip that. I think the main thing to know with the region is that the GCC Patent Office does not accept GCC applications anymore. I think I'm going to go straight into talking about what are the things that you can take advantage of in other jurisdictions as well. So perhaps maybe Vivian, what are the ways that an applicant can sort of help to speed up or delay patenting if they're filing, for example, in Singapore?
Okay. Singapore has a very advantageous so-called IP fast track program. I think it's so far the world's fastest file to grant system, that you can get a patent granted as fast as 6 months from the date of filing. Of course, there's a limited quota per month and a quota for each applicant per year to file patents and request acceleration under IP fast track. The good thing is that it can be applicable for all the tech fields. You just have to state the tech fields and the reason for acceleration when you apply for this fast track. Also, if the quota is met, then you have the 12 months file to grant system. Then you also establish a patent cooperation with Cambodia and Laos to re-register a granted patent in Singapore there. Then around the region, we have the ASPEC program within ASEAN countries. You basically use an earlier search and examination report issued by one of the officers, such as the Singapore Patent Office, to accelerate the prosecution of a corresponding application in another participating member country, such as Malaysia. So in this way, it avoids the duplicative search and examination, and also reduce the workload of the patent office. The good thing is that it doesn't incur any additional official fees, and all the forms and applications are filed in English. So it saves lots of time and money in preparing the various translations for different ASEAN countries here.
Yep.
Then another important thing about Singapore is that Singapore Patent Office is both a member of GPPH, Global Patent Prosecution Highway, as well as a member of ASPAC program. So it is only member in the ASEAN country, which is both GPPH member and ASPAC member. So for any applicants who has business interest in ASEAN region, we would highly encourage them to leverage on these initiatives. For example, to get a patent in Singapore granted as fast as possible through the GPPH program or the national acceleration programs, then use this Singapore patent to gain a gateway to accelerated examination in the ASEAN region through the ASPAC program.
Yeah, I think that's really helpful as well, because, you know, I think generally, if you're patenting in Singapore, you would probably be considering countries around as well in the region. And if there's ways that they can harmonize or simplify that process, I think that's helpful for applicants.
Yeah, I would also like to mention that Singapore, if you file a PCT application with the Singapore Patent Office, it can be filed in Chinese as well. So I think this is something unique to Singapore, and we can also obtain a final international search report in Chinese or English, and it doesn't incur additional official fee. So it actually saves the translation cost for entering China at the later stage.
And I think China is a huge market for most applicants as well nowadays. So that's definitely handy. Yes. Trevor, is there anything that you want to share in terms of developments in your area?
Well, I think that there's constantly developments, and I could probably spend a whole other hour on developments. One thing for Canada is that we just had a whole update to our patent rules, and for those of you that have actually filed in Canada before, you might have remembered some flexibility that we used to have around the number of office actions that would issue and the number of claims that you could file, and you could easily file 150 claims or however that might be. But now, all of a sudden, Canada's rules have changed to be a little bit more similar to the US, where there will be excess claims fees for claims over 20.
Yep.
And there's a limitation now on number of office actions before you either have to file an RCE or a request for continued examination, or the application is essentially rejected. So you get 3 office actions before your first RCE, and then once you file an RCE, you get 2 office actions. So that brings it similar to the US to a certain extent. It's maybe not quite as strict as the US is in terms of numbers of office actions before you get a final action or need to file an RCE, but other things in Canada around using the PPH, applicants do use the PPH a lot, and usually they'll harmonize that together with either their US or their European filing strategy. And there's some nuances to that, but it does tend to be a very effective approach to acceleration if that's something that you want to use. And there's a couple of other acceleration routes that we have, including one for green technologies. So if anyone is working out there that has green tech, you don't even need to pay a government fee. You can get automatic fast track examination for your green tech technologies as long as you file a request before you get your first office action.
That's a great idea. I'd love to see when government gets involved to try to support innovation in particular areas that are strategic.
Exactly.
Yeah. So we're actually running out of time. This is such a big topic that I think maybe we need another hour. But what I will do is I'm going to, obviously we'll share the slides with everyone, but just to sort of skim through quickly what's left, and then we'll address the questions because we've got about 9 of them. So I'm going to jump straight to, we were going to talk about managing IP and agreements, but that's also a whole nother topic, I think, that needs its own webinar. And I think Winsome, you're going to be back for that one. But we can sort of stop at, I think, the KPIs here. So I was going to talk about, if you're running a tech transfer office or an IP management function, you do need to think about how to show the value of your activities. Because a lot of times I think with tech transfer offices, they can struggle to justify their budgets or show the value of what their activities are, because it's such a long-term process until you start seeing impact. And the return isn't necessarily monetary. You're creating an ecosystem, and so you have to you're in it for the long haul. But there are ways that you can sort of track some figures, some numbers to show, just for you to sort of see, I guess, where your strengths are, where your weaknesses are. And then, are you on the right track as well? So these are some of the KPIs I was able to pull from like the associations for universities and tech transfer. Typical KPIs here is that some entities track, and there's a lot more than this that you can probably find. But these are sort of the basic ones that most universities use to track. Winston, before we turn to the questions, I was going to ask you, does KU have sort of a system for tracking any KPIs? If you do, how does that help you?
Well, it's baked into your evaluation. That's
Okay. So it's very important.
yeah. So we do a monthly report.
Yeah.
And it takes into consideration all this too. And one of the things, well, you have spinoffs, well, startups. That's one of the KPIs too. How many license agreements you've done? It's all there. So that's how it's tracked. And we keep track of where we are in terms of how much they think we should have and where we are. Sometimes you meet it and sometimes you exceed it. And the other part is sometimes you don't, so.
Yeah. Would you say, so I'm just going to pick up the questions and just sort of jump straight in. What are some of the ways that you can help to optimize your patent portfolio? I'm going to go back to you, Winston, on this.
So you tie in agreements too. And that does help through licensing, the options, the startups.
Do you do any sort of like filtering of your portfolios as well? Like,
well, we do, and you do pruning too, because you look at projects based on the portfolio, and one of the things that we look at is whether or not the inventors are still here. If they're here, it's high priority, looking at it, see where we are. Is there been any progress? What's the market, what's going on? What can we do with this? Sometimes you can bundle it with something else, or if it's not going anywhere, then you sort of let it go,
Yeah. So we have a few questions from, I think, the same attendee, which I think we'll take offline, just because we're a couple of minutes in. I just wanted to thank you all for participating in this webinar. I think there's so much content here that we might have to do a part 2 at some point. And to the audience, if there's any questions, please email me and I'll make sure that everybody gets to them. I just want to thank you for participating and for attending. And I hope you all have a lovely day or evening wherever you are, and we'll speak soon.